All right, Ray Anthony Espinoza. Morning. All right, good morning. Hello, Mr. Espinoza. All right, so state on this case today, you need to let the court know because I don't know his age or anything.
He was under 18.
All right. So where are we on discovery?
We have just obtained a cell phone, and we just disclosed to the defense that we do have that in our possession now. We got it on last week.
Okay.
We asked her to bring a hard drive today. We just asked her today to bring it in.
Okay.
So we're gonna get her that, and we got a couple other items that were just uploaded last week. And we believe that will encapsulate all the discovery in this case.
And Mr. Foley's my co-counsel on this. He and I've been texting, and he's going to send them a hard drive from Amazon. It should reach them tomorrow.
Okay.
The beauty of Amazon.
Oh, yes.
Hmm.
All right. This is going to be the last date for discovery. And on this date, state, I need you to tender and be prepared to tender an offer. Ms. Ferguson, can you set this for the first week in October? And that will give you a chance to view whatever is on the phone.
That sounds great.
All right, October 10th.
Got
We'll
it.
bring you back on October 10th. On that day, what will happen is the state will be prepared to tender an offer. Once you receive that offer, let me know where we are.
Yes.
And then if there is not an agreement, then your next date may be a plea deadline date or a jury trial date. It's probably going to be a plea deadline date because
Sure.
of his age.
Of course, Steph.
All right, thank you.
Thank you, Judge. May we be
You're welcome.
excused?
Yes.
Right.
I have Alfredo Flores, Elazar Alejandro, and Nathaniel Villalobos. Do y'all want to have this hearing on this state's motion for continuance at the same time or do it separately? All right, you're the only one who responded. So anyone else?
I concur.
Yes. All right, and state, are you okay with hearing these all at the same time?
We can take them up at the same time on the issue of,
The continuance?
yes, Your Honor.
Okay, all right, come forward, everybody.
Your Honor, if you want.
Yes.
Okay, yeah.
Deputy Laura, it's 3 clients, so it may get a little crowded.
Do you want us in the ABC order or does it?
Oh, she will let you know. I'm just calling it, you can do that if you want to,
Okay.
however you want to do it.
I just want to be sure.
Oh, no.
And just move up where the microphone is at.
All right, court is calling 2000. I need everyone to be quiet, please. Court is calling 2023 CR 11510A, State of Texas versus Alfredo Flores. 2023 CR 11510B, State of Texas versus Eleazar Alejandro. 2023 CR 11510C, State of Texas versus Nathaniel Villalobos for the state.
Jeff Mulliner and David Lumen for the state of Texas.
All right, in defense, if you could announce yourself and the corresponding client for the record, please.
I'm Tom Nisbet on behalf of Alfred Flores.
Ben M. Cifuentes Jr. With co-counsel Mario Del Prado for Alejandro, Elias or Alejandro, I'm sorry, Your Honor.
Okay,
Nico LaHood, Jason Goss, and Patrick Valentine for Nathaniel Villalobos, Judge.
all right, so the state has filed the first motion for continuance. Defense, have you had an opportunity to review that motion?
Yes, Your Honor.
All right, state.
Yes, Your Honor. We do affirmatively move to continue the matter for the reasons stated within our verified motion.
All right, do you want to expound on anything before the court makes its ruling?
I can highlight some things that are within the motion, Your Honor. The fact of the matter is, again, this is Jeff Moner for the state of Texas. I did not even know the names of the defendants that are charged individually in this case until approximately 30 days ago today, when I was asked to assume the role of director of the Civil Rights Division. Subsequently, of course, I have been getting up to speed on the cases, but that has been in stair steps. And when I became kind of confident that the cases were in fact mine, it was about 10 days ago or less. And on that date, I reached out to the defense and we set up a Zoom conference. During the conference, there were attorneys representing each of the individuals that are charged in these separate indictments. And I was on the line with Chief Lunan and a lawyer for each of the defendants. And what I learned during that conference is that the counsel for Alfredo Flores, Ben Fuentes, and Mario Del Prado, in fact, told me that they have an expert that is necessary and material for their defense that is not available on the present trial date. I further learned, I'm sorry, that was David Christian and Tom Nisbet have an expert that is not available for the presently scheduled trial date. I learned from Ben Fuentes that he and Mario Del Prado, with respect to Alejandro or Eleazar Alejandro, have an expert that is not available for the present trial date. I learned from Mr. LaHood, Mr. Valentine, Mr. Norton, and Mr. Goss that they have an expert that is not presently available for the current trial date. And I expressed to them in this Zoom conference that Chief Lunan had just recently been asked if he would sit on the case and had not yet had an opportunity to review all the evidence. I had just come onto the case and had not yet had a chance to review all the evidence. We basically agreed that the defense feels that it would be a benefit to them that there are fresh eyes looking at the case in order to kind of just make a fresh assessment as to what we're looking at, what we should proceed on. And so I learned that they don't have an objection to the state's request for a continuance. And so from there, we basically all agreed that each for our own individual reasons had a basis for a continuance, that none of us objected to the basis that was advanced by the others, and that we would all file our motions and submit them for the discretion of the court to consider. So obviously it's your discretion what to do going forward, but on behalf of the state of Texas, we have not filed our motion for the purpose of delay, but rather in an effort to see that justice is done. And we do so urge that the motion be granted.
All right, so I don't have any motions for continuances from the defense, is that correct?
We filed ours.
All right, well, let's pull that so we can put that on the record as well.
Okay.
Does anybody have a motion for continuance?
We filed one, Judge.
All right, can you pull
I'll
that?
pull them up. The e-filing is not quite computing.
Oh, that's okay. Does anybody have a copy of their continuance with
I
them?
have a copy of mine.
Oh, thank you. I knew you would. Anyone else have a copy of their continuance?
Judge, I can email it to your clerk if.
Oh, that would be awesome.
And I suppose I should give you time to read that unless you want me to.
No, just give me
What is your email address?
1 second, Tom, I can pull them off of ours.
Okay, so don't email us.
No.
Okay.
You can send it to me.
Okay. What is it? Norma Dot
And Ferguson.
and Ferguson.
You found it on 820, right?
all right, and so we're also proceeding on a motion for continuance from the defense in each of the cases. Is that correct, defense attorneys?
Yes, Your Honor. And if you want me to,
Yes.
comment on some of the things that Mr. Molnar
that dovetail.
And I'm sorry if you'll state your name for the record.
Ben M. Cifuentes Jr.
All right, so you filed a motion for continuance on the behalf of Mr. Alejandro, is that correct?
Yes, Your Honor. And
You may proceed.
Axon video, there were 109 videos provided. And they're voluminous. I would imagine they'd probably take several hundreds of hours, probably 500 hours to review. We have been diligently transcribing them. But to properly defend our clients, we need to synchronize the videos. We previously had asked the state if they could provide the evidence.com program and the Axon program so we could accomplish this task. The state advised that it was up to the PD to provide the program and they couldn't provide it. So upon learning that, we immediately hired Knott Laboratory out of Colorado to accomplish the synchronization.
All right, and what date was this requested?
The Axon videos, I believe we requested it in the previous setting. I cannot give you a precise date when we were told that it wasn't provided, but I could give you the date when we hired Knott Laboratories, and I believe that was 3 months ago. And they have been assembling these videos, and I think under Rule of Evidence, I believe it's 1006, we would be permitted to introduce these videos as cumulative summaries, and they're vital to our 9.33 defense because the prosecution guide omitted 4 different segments of time that would prove our 9.33 defense. And Sean Knott is the person who assembles these, and he has a trial conflict in another jurisdiction. In addition, we asked for the audit trail for Axon video, and that was not provided to us. And the reason the Axon audit trail is vital is that evidence.com is an evidence-based program that has software that can show when investigators accessed a particular video. And so if they ever accessed the points in time where we believe there's a defense, we believe we're going to be able to show that they did not even look at that. And so if they did not even look at exculpatory evidence in the videos, that would create reasonable doubt in our view. In addition, what we do know from what we were provided is that the videos were not uploaded until well after the warrants were issued. And some of the videos were uploaded in December or September, late September, well after the fact. And it appears from what we've been provided so far that the state, the PD has not even looked at these videos. In addition, we subpoenaed certain records from the DA as the custodian of records, and one of those was a murder case where our client responded to, and where a person was hit with a hammer several times, and there's an issue as to whether a hammer is a deadly weapon. It's a murder case. I will say that I did meet with Mr. Mulliner on Thursday to address this subpoena that we issued that hasn't been complied with, and he is in the process of downloading. I believe he's already downloaded and will provide after this hearing a copy of those files by USB. So we're asserting that without our expert and without some of the evidence that we requested, the audit trail and the homicide file, that we would not be able to present adequately our defense of apparent danger and fear of serious bodily injury or death by a hammer. And that's why we're asking for the continuance. And we were diligent in trying to obtain Mr. Jason Evans.
All right. Anyone else want to have from the defense? Mr. Nesbitt?
Sure, Judge. Tom Nisbet on behalf of Alfred Flores. We filed our motion continuance first motion under several provisions, 2906, 2902, and 2903. It's our understanding with the state that the unopposition is something of an agreed, but we also set forth the appropriate reasons under 2906 that our expert, which was duly noticed to both the state and the court and filed as such, Mark D. Sawa, is unavailable for the present trial dates. Despite counsel's diligence, he is a material witness. He is a nationally accepted expert in police practices, use of force, self-defense, and tactics, and goes to the very critical heart of the defense in this case. I would say to both the offense and the defense in this case, right? It is the critical issue in this case. His unavailability would deprive Mr. Flores of his right to due process and a fair trial. He is a retained expert. Considerable time and resources have gone into his preparation for the trial, and he is still receiving new evidence that we are obtaining and giving to him for his review. Judge, we agree with the aforementioned technical reasons that Mr. Cifuentes gave. Mr. Cifuentes and I spent a considerable time over the weekend looking at all the audit trail documents, and they are in fact missing any time signature, timestamp, identification, or any other evidence that someone looked at any of the body camera videos prior to September of 2023 in this case. So either that's not right, or that seems very, very problematic considering that it happened and they were all arrested in late June of 2023. So there has to be something missing there, or it is a major issue for the state and is extremely exculpatory, and either way needs to be vetted to the maximum. Anecdotally, we have heard in our investigation of this case of a type of chilling effect that has gone on in the San Antonio Police Department. What I mean by that is that officers who are presently serving in different ranks and capacities at the San Antonio Police Department have been discouraged from stating an opinion they may have that could be different from that of Chief McManus and the very administrative and political position that he speedily took in this case on the incident date. It is our opinion that a further investigation could show that there are good witnesses, exculpatory witnesses with exculpatory opinions to the defense, and we have been diligent in trying to examine those. There have been some new leads that have come up in the last couple of weeks. We have expressed all of these things and more to Mr. Muller and Mr. Lunan, and they have pledged the utmost due diligence and ethics in following up and being fair, trying to discover these exculpatory things. But I guess the best analogy I can give is it's kind of like, you know, the string on the sweater. You give it a tug and then it keeps coming. And that's sort of the situation that we're in right now. For all the aforementioned reasons, under Chapter 29, we would urge our first motion for continuance, and we are unopposed to any of our co-defendants or the state. And then I guess I will add, Judge, for the reason also listed in our motion, that it is the solemn desire of all three defendants and their attorneys to try this case together in joinder. So for that reason as well, we are not opposed to the motion for continuance.
And I apologize, Your Honor, I failed to state, but I do agree with co-counsel that we do wish for joinder.
All right.
And Jeff Mulliner for the state, I should drop a footnote to come back and address this matter later after counsel from Mr. Villalobos have an opportunity to address the court with respect to their motion for continuance.
All right. Yes.
Judge Patrick Valentine from Nathaniel Villalobos. We agree with and join in the arguments of our colleagues just made. I won't reiterate the points that they put before the court. I will say particular to our motion, we are seeking a continuance in parts based on the unavailability of a material witness, that being Dr. Ron Martinelli. Dr. Martinelli is a nationally recognized expert in the field of police procedures and use of force. He has been retained by the defense to consult and provide testimony on the issues of the reasonableness of defendant Villalobos's use of force, the justifications of his use of force, and the integrity of the police investigation that was conducted. He is necessary and material to the defense. He is unavailable on the dates presently set for trial. I do have dates when he will be available for the court, should the court grant our motion for continuance, and we so ask the court to do.
All right, and you wanted to add something?
Yes, Your Honor. Insofar as it has been mentioned, the concept of a joint trial, I wanted to speak directly to the court and indicate that it is my understanding, based on some questions that I have asked, that the state of Texas has quite possibly seemingly joined in a joint trial insofar as the state has failed to object to proceeding with the joint trial. It's my understanding from a review of the law that ultimately it's going to be up to the court whether these cases are joined or severed.
Well, what I can tell you is both parties agreed. And when I say both parties, I mean the state and the defense attorneys informed the court that they wanted these cases tried together. Is my memory wrong?
Correct.
That's our memory, Judge.
And there was no objection to the joinder. Now, as far as a motion of joinder being filed, the court has not received that. But we're all attorneys. We're all officers of the court. I don't think anyone would do anything that was unethical, but it was the court's understanding that the defense wanted these cases joined, that the state did not object to the defense wanting the cases to be joined. So is that going to be changed from the state's perspective?
Yes, Your Honor. My understanding is that the defense has, at a prior hearing, all agreed verbally in their desire to have a joint trial, and that my understanding, I wasn't there, and so I would always defer to a record or to a memory, but my understanding as someone that was not there is that the state literally did not object to what was understood to be kind of a consensus among the defense as to having a joint trial. And since—
Well, specifically what the state said was, yes, it will be a joint trial. Now, if people want to change and file motions, you can file your motions.
Yes, Your Honor. So,
But what I can tell parties is that based upon how I rule on the motion for continuance, that ship may have sailed, because it was agreed by all parties that this would be a joint trial. And if my memory is incorrect, I know you all were not here, but if my memory is incorrect, please let me know.
It might have actually been two sequential hearings where it was addressed and assented to before the court. It's my memory, not just a single hearing.
All right.
Your Honor, if I may, all I can say is when I was asked to come into this case, and when I first conferred and consulted with David Lunan, who had at that time just recently been asked, would he sit with my predecessor? When we were looking at the three separate cases that are here before the court, we each independently concluded very rapidly that there would be severe evidentiary problems to the cases for the state of Texas. Would there be a joinder, and specifically the confrontation clause? It's our view that if these cases were tried jointly, which I understand historically what the court has said about what has come before, but only speaking prospectively from our view, since the cases have not yet been tried, it is our view that if this were a joint trial, a great deal of the substance in this case that would be available, for example, just using the names, since if we wanted to put on the evidence that would be available against Alejandro Flores, much or most of the statements that Alejandro Flores had made either on body cam, his or others where his statements are heard, or in a statement that he had provided, would and likely could be objected to as denial of right to confrontation by Villalobos or Alejandro. Similarly, if we were trying to put on evidence as to Alejandro, there would be confrontation problems that could or likely would be advanced by Flores or Villalobos. And similarly, if we were trying to put on evidence against Villalobos, there's confrontation clause arguments that could be advanced and likely would be advanced by Alejandro and Flores. So with a joint trial, we see the evidence as being severely watered down insofar as by the time we got to
Oh, no. So let me just explain something to you. If you all have decided to have a joint trial and strategically, there are some issues with the confrontation clause. You know, people think, oh, this statement won't come in because we have a confrontation issue. Then that's going to be resolved with a jury instruction. Unless there is some other case law that somebody can bring me that will explain to me why, if 3 co-defendants decide they're going to try their case together, and maybe hypothetically a co-defendant is saying, I'm not going to testify, or another co-defendant is not going to testify, and then therefore statements don't come in for the other co-defendants, excuse me, off the record. All right, thank you. No toddlers in the courtroom. All right, we're back on the record. So the court will take that up through objections at that time if that were to occur.
Yes, Your Honor. And also, I have heard, same as the court, that the defense is proceeding with what at least generally can be described as a joint defense agreement, but I have not seen a document to reflect the same. I certainly haven't seen signatures. And again, just hypothetically, for example, in this case, I think it's beyond dispute that Alfredo Flores held the rank of sergeant on the date of the alleged incident that's the subject of these 3 separate indictments. And the other 2 defendants in front of you, Villalobos and Alejandro, they had a rank of patrolman. And so there are, of course, distinctions in their role there at the scene. And from our perspective, we can't see how it would be possible for us to attempt to provide the evidence that's available against Flores, given his supervisory rank.
All right, so just a second, because we've strayed off the path of the motion for continuance, but this is what I will say. The state and defense agreed that all of the cases will be tried together. Now, if someone is now saying, we don't want to do that, you need to file a motion.
Yes, sir. Yes,
Court
sir.
will hear the motion. So we're not dealing with that now. The only thing we're dealing with right now is the motions for continuance.
Understood. Thank you, Your Honor.
Sure. All right, so this is what I can say. In each cause number, the first setting in this court was January 29, 2024. It was for discovery. Then we came back on February 26, 2024 for discovery. Then we came back on April 29th for discovery. Then we came back on May 28th for discovery. Then on May 30th, we came back and I was told that all the discovery was received. All of the defense attorneys signed off on the acknowledgement of discovery. Then there was a plea deadline date set for June 27, 2024. And on June 27, 2024, jury trial was scheduled for September 24th, 2024. State, with regards to your playing catch up, the jury trial is September 24th. That's more than 10 days because today is August 26th. And each of the cause numbers for state and the defense, the motion for continuance is denied. And because of, I think Mr. Nesbitt said, we need more room for jury selection. So jury selection is going to be on Friday, September 20th in the central jury room. Is there anything else? All right. And then for experts, have you all subpoenaed them? That would be a no, right? No experts have been subpoenaed.
We've retained them.
All right. All right, thank you.
Your Honor, may I have my copy back?
Oh, yes. Oh, I'm so sorry. Let me find your copy. And you are with, who's your client?
Alejandro.
Alejandro. Just one moment. All right, Jennifer, can you do me a favor? Can you make a copy of this?
Yes.
And I sign this one and I will get a copy of it.
Okay.
If you can make him a copy and give me the original.
Yes.
All right, thank
Go
you.
back and do that real quick.
Oh, excuse Judge?
Yes.
Thank you.
All right, Mr. Aceves. Hello.
Hi, Judge.
Oh, you're on this side.
Good side.
Hello. Each day you come with a cleaner haircut. So how's everything going with you?
Pretty good. Well, in my job, I got a raise 3 weeks ago, and
Awesome.
I was able to pay off my car loan, and all that. As for now, I try to help my family pay off the debt so we can all be free of debt and we can start saving for the future.
Oh, that is so awesome. Vashawn, how's he doing?
Judge, there are no concerns on this end, everything, he's reporting as needed, everything is good.
Okay, awesome. Do you need anything? Do you have any questions about anything?
No.
Okay, so let me see. All right. Ms. Abrams, I can have him come back to check in the week of December 16th or either after the 1st of the year. This is just so I can keep tabs and see what's going on in your life, okay?
Your Honor, if I may,
Mhm.
I have the whole month of December blocked off for vacation.
Okay, so we can do it January.
January the 6th,
All right.
if that's okay with the court.
January 6th. Are you good for January 6th?
Yes, sir.
All right, so Ms. Ferguson, if we can recall this for January 6th. 2025. All right, so as I've told you before, if there are any issues that come up, you can let your probation officer know. If you feel as they're not addressing it, you can always come back to court, okay? Keep up the good work and thank you for always dressing it appropriately for court. All right, and congratulations on your raise. All right, have a good one.
Thank you.
And Jenny, Ms. Ferguson will give you a reset form if he needs one.
Okay, thank you.
All right, who is here on Enrique Soriano?
We approach.
Yes. All right, today state you were to tender an offer. Were you able to tender an offer?
I thought we were here for discovery, Your Honor. We
It's
have not
supposed to be
received that.
acknowledgement of discovery and an offer is supposed to be due today.
We do not have an offer from them yet, Your Honor.
All right, so you have all the discovery?
We do not have the discovery, Your Honor.
All right, what's the issue with discovery?
Two issues. We recently learned that there are no data cam recordings from the agency that detained and investigated and arrested Mr. Soriano. We further know that Texas DPS Crime Lab Houston takes 90 days to process and produce requests for blood discovery.
All right, so when was the blood discovery request given?
Approximately 4 weeks ago, Your Honor.
I believe the order was originally signed in June, and I think the
Mhm.
state forwarded over to DPS in 4 weeks ago.
Why the late transfer to DPS?
I couldn't tell you, Your Honor.
Because if I signed the order in June, why was it just sent out 4 weeks ago?
That I don't know.
All right, Ms. Ferguson. Recall this case in October. state in October, you need to be prepared to tender an offer to the defense. What date, Ms. Ferguson?
You said mid-October, Judge?
Yes. All right, we're going to come back on October 14th. Thank you for dressing appropriately for court.
My
Once you
pleasure.
sign the reset form, you're excused, okay?
Thank you.
Thank you.
Thank you, Your Honor.
You're welcome. All right, who's here on Stephen Carmona?
That's mine also, Your Honor.
All righty. Where's Mr. Carmona?
Walking up, Your Honor.
Are you all ready to proceed?
I am.
Okay.
Can I get my clerk sheet out?
I'm sorry, what?
My little clerk sheet.
You're welcome. All right. Are you all ready to proceed?
I don't know.
I believe so. We haven't the MTR and we have the DWI that the last time we were here, you mentioned about the blood alcohol content results.
Mhm.
We got a little bit of something on that today.
Mhm.
So those are the two topics we need to discuss today, Your Honor.
All right. Do you want to confer with the state and see where?
We have.
We just haven't resolved the MTR at all.
Oh, well, I didn't talk to you. about the
Yeah.
MTR.
Okay, so you all want to step back for a little
Okay, let me
bit?
try.
All right,
Let's try it
thank you.
again.
Thank you, Judge.
All right, who's here on Stephanie Clegg?
No, it's not for continuance.
All right, so what's going on?
I was just served a new motion to revoke probation on Ms. Cleed that is, pardon me, a little frog in my throat, that is dated today. I
Okay,
would ask for a continuance.
all right, that's going to be granted. Ms. Ferguson, on this case, can you set it for contested in 20 days, please?
Thank you, Your Honor.
All right, thank you for dressing appropriately for court. Just give us a moment. We're going to get a reset date.
Thank you, now.
You're welcome.
Okay, go ahead and have a seat.
Okay, so where are we on this case?
Judge, it looks like it has to be contested.
Okay.
It's just that we don't have an agreement at this point.
All right, counsel, you asking for a contested hearing?
Well, yes, Your Honor. Yes, ma'am.
All right, Ms. Ferguson, can I have a contested hearing on Carmona?
September 17th.
All right.
If I may, let me look. 17th is fine.
All right, so once you sign the reset,
May we do the 16th?
Ms. Ferguson, they're asking for the 16th.
Okay,
All
thank you.
right, so once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Yes, ma'am.
All right, you may have a seat.
Thank you.
You're welcome. All right, who's here on Eric Gonzalez Lopez? Is he here?
Yes, he is. You
Oh.
have a translator.
All right, come down, Mr. Lopez.
Morning, Your Honor.
Good morning. How are you doing today?
I am well. How are you?
Oh, I'm doing okay. All right. So in this case, this is where the court is with the cases being transcribed, or at least the jail calls. So the case with Mr. Guzman, that translation has been completed. And then they're going to start on the next one, and I believe it's your clients that will be next. This is what the court is going to do. They have a USB drive for Mr. Guzman. They're going to put it in my office. I am going to make a copy of it and give it to his attorney only. And I'm going to review it to see if there's anything there. And then if I determine that there is nothing there, then the only person who will have that USB will be his attorney.
Understood.
All right. Now, I know there are certain issues of whether or not someone who is passing themselves off as an attorney, whether or not that's privileged or not. So I'm reviewing that. If there's some case law you all wish to present to me, you can. However, I will tell you, if the defense wants to present something, or if it appears to me from reviewing the interactions through jail calls and jail videos with the person pretending to be an attorney, if it appears to the court that that person was presenting himself as an attorney, and if it appears that the defendant thought that person was an attorney, I don't think ethically it would be fair to breach that just because the person is not legally an attorney. I think that would be not fitting with the spirit of the rules. But if someone has any of the information for the court that they deem my interpretation of that is incorrect, let me know.
I agree with that approach, Your Honor, and I'm assuming that the procedure that you're saying you followed with Mr. Guzman and intend to follow, that would be the same roadmap for how you're gonna do with, how you're gonna deal with my client's statements as well. And I am in agreement with that.
Yes, that's how I intend to proceed. Now, there's a second issue, and you may want to confer with the state with that. My understanding is that the state, I don't know if they have filed charges
I don't.
against the person or not, but of course, in order to prove that case, they may need that information for that case. And if that information is going to be used for that case, then we'll cross that bridge when we come to it, or whether or not it's discoverable, or they should have it to prove another case against someone other than your client. My only concern is if it's something that is incriminating, of course, there would be an issue of you're not using it for trial against either of the defendants in this case. It's just very complicated. And so we'll cross bridges when they're built. So I don't know how long it's going to take to transcribe for your client, but it does take a while. So I'm going to reset this for November. And if we have all of the translations by that time, great. If we don't, we'll see where we are. I just don't think it's fair for anyone to proceed without the transcripts.
Agreed.
All right, Ms. Ferguson, can you give me a November setting on this case? And state, you're not intending to try these cases together, are you? All right, so then we may be able to start proceeding with Mr. Guzman. All right, we'll come.
Judge, I was just looking at my calendar. I was gonna say the only week that probably is gonna be a rough one for me is that week, because I have a trial scheduled in Comal County that I believe will likely go.
All right, Norma, can we put it the week of November 4th?
Yes.
Could we do it on the 7th?
Perfect.
All right, is there anything else?
No, Your Honor, thank you.
All right, Mr. Lopez, do you have any questions?
No.
All right, thank you.
Thank you, Your Honor.
You're welcome.
All
right.
First row, sir. First row. On the other side.
On one of the allegations today
Oh,
and try to close it out.
okay. All right, so, but you're gonna still want to address the GPS, correct?
Yes, ma'am. Yes, ma'am. If things go well for us, yes, ma'am.
All right, okay. All right, then we'll proceed on this. All right, the court is calling 2023 CR 8639W, State of Texas versus Stephen Carmona. Could I have the parties announced for the record for the state?
Jason Garrett, Your Honor.
Defense.
And Johnny Cisneros.
And are you Mr. Carmona?
Yes, Your Honor.
All right, is your name Stephen?
No, it's Stephen Samuel.
Okay, I don't, on the motion to revoke and all the paperwork, it says Stephen.
I think that's because the way the DPS issued my license, they put Stephen.
Ah, so your license is Stephen.
Yeah.
Ah, okay,
I've called and tried to get a new one, but.
all right. Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney?
Yes,
Did you understand it?
I did.
Are you the same Stephen Carmona who was placed on deferred adjudication in 2023 CR 8639W for the offense of repeated violation court order bond condition on October 3rd, 2023 for a period of 6 years? Is that you?
Yes, Your Honor.
All right, state.
Yes, Your Honor. Violating condition number 2 on or about the 5th day of October 2023. Bear County, Texas. Defendant Stephen Romano, resident there, should not hold beverages violation condition number 2.
How do you plead to that? True or not true?
True, Your Honor.
All right. Excuse me, can I have a stamp for a motion to revoke? All right, thank you. And state with regards to the other violation?
Will be, one, allocation.
Any objection?
No objections, Your Honor.
Okay. Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in prison and up to a $10,000 fine?
I do, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Your Honor.
Court will find violation of condition number 2 true. Is there a proposed agreement?
No, there's not, Your Honor.
All right, state, what are you recommending? All right. And defense?
Judge, I'm recommending that you continue him on probation. He's been doing good. He's been on the GPS for 11 months approximately. And he hasn't had any violations. It's in the actual report that there's no violations. There haven't been any violations. And other than drinking alcohol that day, he's been doing wonderful. He's doing good. He's been following my advice. He's been following the court's advice or orders. And he's doing great, except for that one mistake, bad decision, not a mistake, bad decision. And I'd like for him to just continue him on probation and let's keep seeing how he continues. And if he continues to do well, then he'll be successful.
All right, so last time we were here in July, the warrant was recalled. And I asked that he complete daily sober meetings. Has that been done?
No, Your Honor. I recently have.
Let me have you raise your right hand for me.
Oh.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Stephen Carmona.
All right, so I ordered daily sober meetings. Why hasn't that been done?
I recently got an employment as a director of operations in a call center. It gives me 7 to 7 hours, Monday to Friday. I also have a 5-year-old that I share like joint custody with. So I have him anytime his mom is at work. She works in the evenings. So she goes in anytime between 7 p.m. and 9 p.m. So because of that, I couldn't find any virtual AA meeting. And the only ones that I could attend would start at 10 o'clock.
All right, so did you come into the court and tell me or tell your probation officer, hey, I know the judge ordered daily sober support meetings, but here's the issue I'm having?
I did tell my probation officer this past time that I saw Ms. Guerra, and she did tell me that I could go online for resources, and she provided me a link and information so I could go and start attending them. This was this past week.
All right, so I had ordered that since July 11th. Why are you only doing it this past week?
So initially, when I did talk to my probation officer, Ms. Guerra, she had told me not to report because of the fact that the systems were still showing an active warrant. So the last time I was in here, I was detained. I thought it was for failure to appear here, but it was, she told me that it was failure to report, which I wasn't aware of. And when she did call me and tell me, that's when I went and reported, and that's when I gave her all the information.
All right, any other questions?
Nothing to understand.
Ms. Abrams? So has he spoken to his probation officer about the sober support meetings?
That I was just reviewing, the notes on the case,
Your Honor, if I may,
Yes.
I would like for you to continue him. And I will promise you, I will have a very stern conversation with him about following the court's orders. I know it's July and then August, so we're missing a few days here that he didn't do what he was ordered to do. But I will have a very stern conversation with him. I will tell him, as he already knows, the possible results of what can happen if he doesn't follow the court's orders. But I've gotten to know Mr. Carmona since he retained me. He is a fine young man. He has been doing well with the orders other than the alcohol consumption and this. So if I may get in a little bit of an extension for him so he can start doing what he needs to do. And then we're due back in January. So on the other case, and we can come on that day or we can come anytime in between there, Your Honor.
All right. Ms. Abrams?
Yes, I did review the notes that were in the system and no notes indicate that conversation was had in regards to social support.
All right. So let me ask you this. Is it possible to have his probation officer zoom in?
Judge, the probation officer listed is on modified duty. I can make sure, due to health reasons, I can make sure she's in the office and see if she can.
All right, then if she can't zoom in today, I can recall this. I've accepted his plea of true. And we can recall it for a date where she's able to zoom in.
Seems like 5 minutes, but
Sure. All right, if you all will step back.
Thank you, Your Honor.
You're welcome. Renee Signs.
Present.
Oh. And Daniel, you've had a new haircut too. All righty.
I was saying, you got bangs and he lost hair.
I took his hair to make my bangs.
He's got plenty of it, Judge. Take all you want.
All right, so there's supposed to be some labs on a drug test. I mean, sorry, on a drug case.
Judge that still has to come back. I have made an offer encompassing that case, so.
Okay.
And that's correct, Your Honor.
All right, how old are you, sir?
50 years old.
All right, Ms. Ferguson on signs, can you recall this in 2 weeks for a plea deadline date? All right, and why were you late for? Norma, 2 weeks.
oh, I'm sorry.
Oh, no. You're right, we are at the end of August. No, that's good, thank you. I feel like we're in July. Time is going so quickly. All right, Mr. Sines, why were you late for court? You cannot do that. Do you understand?
Yes, ma'am.
9 o'clock. That's when we start. You understand? Do not be late again.
Yes, ma'am.
But thank you for, even though you were late, thank you for dressing appropriately for court. All right, once you sign the reset form, you're excused. September 10th is going to be your plea deadline date. After that, the court will not consider any plea bargain agreements without good cause. Otherwise, you have to appear, otherwise you'll have to plea open to the court. Do you understand? All right, just have a seat and they'll give you a reset form.
Thank you, Judge.
Welcome. All right, Dean Delgado. Hello.
Judge.
All right, where's Mr. Delgado?
Don't know, Judge.
All right.
I did contact him and spoke to him on Friday. I tried calling him yesterday and got a message, the subscriber you dialed. Yeah. And I also tried this morning as well too, Your Honor.
All right, do you know if he is on a commercial bond or no?
Commercial line?
Yes.
I think that's just a regular cell
Or is it a
phone.
PR bond?
Oh, okay, a
Yeah.
bond, okay. Yeah, he's on a commercial bond, Your Honor.
Did you call the bondsman or?
No, I haven't called the bondsman.
You want to call the bondsman, otherwise it's going to be a BF that's going to be issued.
Yeah, I'll go ahead and contact the bondsman.
All right, and then if you come back and if there's no luck, then we can hear it.
Okay.
All right,
All
thank
right.
you.
Thanks, sir.
All right, Taj Davis.
Judge, what happened was he was on parole at the same time he was given deferred. We have worked on getting him a hearing on his parole, but he hadn't had a hearing yet to see what's gonna happen for sure on that.
So he has a parole hearing scheduled.
Okay, Judge, so the last time we were here, we knew that he had a parole hold, but we didn't know what was gonna happen so I'm sorry, when is his parole hearing?
We think in the next 2 weeks.
I saw my parole officer last Tuesday and I had asked him when the revocation hearing was gonna be. He said most likely this week or the following week for sure.
Okay, so then we'll do is recall it and see what happens with parole hearing. And based upon what happens with that, you can speak to your attorney, and then y'all may decide a request to do something with this case that you're on probation.
This week.
So what we'll do then is I'll reset for the week of September 16th, but if you know something sooner, you want to come over sooner, I can let the court know.
Can I put it at the end of that other week, Judge? I'm out the last 2 weeks of September.
September 12th.
12th is good.
Nora, can we recall him for September 12th? Yes, ma'am. Taj Davis. Yes. All right, we'll bring you back on September 12th, if your attorney wants you brought back over, so he'll let us know.
Thank you, ma'am. Thank you, Judge.
All right, Jesus Perez?
Yes, Judge, I'm on that case. We're reset for today. I had my jail visit with him over the weekend. But I'm set in impact court this morning in the 399th and we're number 1 and I'm supposed to report back at 11.
All right,
So
you're reporting back at 11?
right.
All right.
Well, she wants me there by 11.
All right, Deputy Laura?
He's on
what
his
is-
way up, Judge.
All right, he's on his way up.
I'll confirm.
All right, thank you. And who's the judge in impact?
You said Judge Jarrett. Judge, you said Jarrett?
Jared, yeah, it's.
All right, I'll text her and let her know. All right, are we ready on Carmona?
Yes, Your Honor.
Okay, I'll text her. Court is calling 2023 CR 8639W, State of Texas versus Stephen Carmona for the state,
Jason Garrett,
for the defense.
Johnny Cisneros.
And are you Mr. Carmona?
Yes, ma'am.
All right, so we have Officer Norma Guerra here. Any objection to the officer appearing by Zoom, state
no.
defense?
No, ma'am.
Do you have any objections to her appearing by Zoom?
No, ma'am.
All right. Ms. Guerra, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Officer Norma Maya Guerra.
All right, any objections to the court just getting to the crux of the issue?
No, ma'am.
All right, so officer, the court ordered Mr. Carmona to do sober support meetings daily beginning July 11th until today. Mr. Carmona has testified that he spoke to you about his inability to do the meetings. Is that correct?
Sober meetings were never discussed with him.
We discussed it on the exit when I was leaving.
On the exit when you were leaving, I don't
Yes, ma'am.
recall talking about sober meetings, sir.
All right, so Officer Guerra, did you ever speak to him about sober support meetings?
No, ma'am.
Did he ever speak to you stating that he was unable to do his sober support meetings?
Not that I can recall, Your Honor, no.
All right, any questions?
Nothing from the state.
Any questions?
No questions, Your Honor. Just re-urge my argument.
All right, thank you so much, Officer Guerra.
You're welcome. Is that it, Your Honor?
Yes,
Okay.
thank you.
Hmm?
All right, so the officer has testified that no one spoke to her about sober support meetings and the inability to do those.
We spoke, Your Honor. It was on the exit because I had told her that I was ordered to do 7 days daily, and she was surprised because I felt like it was a lot for me to do, given my situation, my income, everything that I have to pay for. She's the one that told me. I told her that I've researched 12, and 12 I need to be a member to do the virtual meeting at 7 o'clock in the morning. She also was the one that said, well, I've had another person that I've been working with, and I advised him to Google virtual alcohol meetings. It was on the exit as I was leaving probation. I wouldn't come up here and put myself at the mercy of the court trying to claim some ownership for what I've done. I understand that it's wrong, right? I do. I fully take responsibility for that. My thing is that, you know, like I was telling Mr. Cisneros, is on paper, it might look like I make money, but I got a mortgage, I got child support, I got utilities, I got other fees like GPS and probation and bondsmen. And so when it's all said and done with, I'm limited. You know, I got my 5-year-old that I take care of half the time, so his mom can go to work in the evenings. I mean, there's a lot of things that I'm doing, you know, and that's where I ask for you, please, to reinstate my probation. And, you know, it's one of those things where I've gone through a whole bunch of stuff. My divorce after 18 months was finalized in July. It's just a whole bunch of stuff that's been going on. And
All right, any questions, State? All right, so Ms. Abrams, in State, in the defense. So in this case, the person I have before me, this is his first motion to revoke, and it's for drinking alcohol, which he's not allowed to drink alcohol. I know I ordered sober support meetings, and that wasn't done. And I do know that I tell everybody, if there's an issue, you can come back to court and address it with me. And I guess when I order people to do things, they're like, you know what? Let me just come before the judge and say I wasn't able to do it. Instead of coming in, nope, don't give me attitude. All right. Instead of coming in and saying, I have an issue with sober support meetings. This is what's going on in my life. Then that could have been something that perhaps we could have figured out. But when people are doing their own things and then come to me at the end of the day trying to figure something out, something should have been figured out in July.
I agree.
Your Honor.
I don't mean no disrespect at all, you know, and it was maybe something that I just didn't know. I mean, I have called up here to the courts and I talked to, you know.
No, I tell people to come in.
Yeah.
Do I not tell people that they can come into court?
I
Just one
understand.
second, Ms. Abrams, there's something you wanted to say?
Oh, no, Judge.
Okay. All right, so
Judge,
then,
if I may say one more thing.
yes.
And excuse me for interrupting. The probation officer opened the door about there being a possibility that he did talk to her about it, because she said, not that I can recall. So I'm believing my client that he did talk to her about it. And of course, there's still the he said, she said situation, but she herself, and I'm going to repeat myself, but she said that not that I can recall. So I think, again, if I may re-urge my request of the court to just give him another chance, I'll have a very strong and stern meeting with him and conversation, and tell him that it's, while we understand it's a zero tolerance policy now, I will make sure and reassure that he knows what zero policy means, and we can put him on or zero tolerance. So I'm asking for one more chance for him. I've gotten to know him, like I mentioned. He's a wonderful young man, just didn't follow the court's orders, and I don't think he understood the gravity of the situation. And we're just asking for a continuance, Your Honor.
Anything else from the state?
No,
All right. Anything else from probation?
Judge, I would like to point out that Mr. Carmona has completed his parenting classes, which gave him full credit for his community service hours. He has given 3 negative UAs. He is paying toward his fees, being on GPS, he's not received any other violations.
Okay.
So just those points to give the court to consider.
So what he has done as a violation of his probation, he was placed on probation October 3rd, 2023. And this is his first violation, and it's drinking alcohol.
That's correct.
All right. You are not allowed to drink alcohol while you're on probation, period. Doesn't matter if you're in your house, doesn't matter that alcohol is legal. Those are the rules that the legislature set up. It is not my rule per se. It's the legislature's rule. You're not allowed to drink alcohol. Do you understand? All right. I'm going to continue him because this is his first motion to revoke and it's for drinking alcohol. I'm not removing GPS. That's going to be a punishment.
Understood.
So he's going to have GPS for 60 more days. Do you understand?
Yes, ma'am.
Is there anything you do not understand?
No, ma'am.
And I want those sober support meetings, and you're going to do sober support meetings 60 in 60 days. Do you understand?
Yes, ma'am.
Is there anything you do not understand?
No, ma'am.
And for the last time, this is what I'm going to say. If there's an issue, let your probation officer know. If you feel as though they're not addressing it, you can walk into this courtroom. Do you understand?
I do. Yes, ma'am.
All right, thank you.
Thank you.
Yes.
I apologize. During his last TAP evaluation, it was, based on the information that was provided, substance abuse treatment was not recommended at that point.
Mhm.
I would like to see about getting another TAP recommendation completed based on the offense that was, the drinking alcohol, and then maybe a little bit of his previous, criminal history.
All right, so it's going to be deny the motion, alternate amend conditions to include a TAP evaluation, out of custody, follow TAP recommendations. If TAP recommends inpatient, we'll start with outpatient treatment. There's going to be 60 sober meetings in 60 days and 60 days GPS.
Your Honor, would the court be open to an oral motion for the waiver of the fees of the GPS?
The only thing is I can ask that they be deferred and waived, but that's a third-party contract.
Okay. Thank you, Your Honor.
All right, is there anything else?
Not from the defense, Your Honor.
All right, thank you.
Thank you.
Thank you, Your Honor.
Thank you. All right, Ms. Garza, who's your client? All right, Jesus Pettis.
I apologize.
Court is calling 2022 CR 3531W, State of Texas versus Jesus Pettis. Can our parties announce for the record for the state?
Continuous support for the state.
Defense,
Anita Pettis for the defense, Judge.
are you Mr. Pettis?
Yes, ma'am.
Did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Jesus Pettis who was placed on community supervision in 2022 CR 3531W for the offense of possession of a controlled substance, penalty group 1,
Yes, ma'am.
1 gram to 4 grams? All right, is there any motion or a motion to add to the allegation, to add that Mr. Pettis is on probation for possession of controlled substance, penalty group 1, 1 gram to 4 grams in the motion to revoke?
Yes, Judge David made more motion to add the 1 to 4 grams.
Any objection?
I don't know what's going on. Oh, okay, got it. Yeah, that's fine. No objection, Judge.
All right. So are you the same Jesus Pettis who was placed on community supervision in 2022 3531W for the offense of possession of controlled substance, penalty group 1, 1 grams to 4 grams on April 12, 2022 for a period of 6 years? Is that you?
Yes, ma'am.
State?
Violated condition number 4 in Baird County, Texas, defendant Jesus Pettis did then and there failed to report to the supervision officer as directed for the months of January and February 2024 in violation of condition number 4.
How do you plead to that? True or not true?
Judge State waives all of the violations.
Any objections?
No objection.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, sentence you to $1,000 fine and 6 years in the prison? Knowing that, do you still wish to plead true to violation of condition number 4? You need to speak up.
Yes, ma'am.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes, Judge, the proposed agreement is to deny the motion to alternate include ISP and referral for the drug court long custody.
All right, so here's the court's question. He hasn't been seen since January. Where has he been?
I defer to my client, Mr. Pettis.
All right, you want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes,
All right, if you can state your name for the record.
Jesus Pettis.
All right, where have you been?
I have been working and was vending as a vendor in the Mexican restaurants selling palm leaf crosses. I make the crosses out of palm leaves and the leaves. And that's what I've been doing, just minding my business, going to work and staying with my friend Irene in her house, and I've just been staying back and forth at the address that I gave you for probation. And that's what I've been doing. I've been staying clean, sober.
Well, we don't know if you've been clean or sober
Of course,
because you
I
haven't been reporting.
Yes, of course.
So I
you
don't
have to
believe that.
assume- Yeah, you would have to assume the worst, of course.
No, it's not an assumption of the worst. Part of people, if you're in your sobriety, then you follow through on your commitments.
Correct.
You didn't report, so I know you were probably still using. That's why you didn't report.
Yeah, just if I may, so my client was supposed to report as part of a DDRF MIC program. I think my client obviously is someone with a diagnosable mental illness. He does have diagnosis for bipolar and what else did you say?
Oh, and major depression, schizoaffective.
And schizoaffective disorder, Your Honor. I know that he made some attempts and he did not have a phone. I don't know if the court.
But didn't he have a car?
No, Judge.
Well, how did he get to his work? Was his employment outside his house?
Yeah,
Walking
he just
bus.
walks, Judge.
Wait a minute.
There is
He
a
said
witness.
walked in bus. Then why can you take a bus to your probation officer?
With excuses.
Okay. Yes.
Yes, Judge. And with respects to our witness, Irene, I've made several attempts to contact her and I have not been successful. Otherwise, I would want some further testimony for the court. All I can say is that I don't know if he would be a good probationer. Mr. Pettis has never been to prison before. He has obviously, I don't know if the court has the report from the PSI. He's only had some misdemeanors. This is obviously, it will be his first felony, so I would hope that the court would follow our agreement and our understanding that he should be given 2 years to do, Judge.
All right, so here's your choice. Sometimes I can give people choices, sometimes I cannot. Do I think you need inpatient treatment? I'm sorry. All right. Do I think you need inpatient treatment? Yes. And probation, did they confer with you?
Yeah, that's why I'm a little confused, but
Right, because,
that wasn't.
right, I understand.
All right, so stop. We're on the record. So, probation, what were you saying?
I thought that we had agreed, there was some miscommunication, Judge. So, when defense and I spoke, she asked that, if I agreed to the revocation.
That's correct,
And
Judge.
we did agree. But I think it was miscommunication with defense and state.
Right, Your Honor, because I think originally the defense asked if I would follow this recommendation. That's where I asked her to speak on Sean.
Okay.
And I think that might have been the miscommunications there.
All right, so this is what the court will do. I'm going to give you a choice. Right? You can either do 4 years in the prison or you're going into inpatient treatment and it's not ISF. So I can either, well, I will refer you to SafeP if felony drug court does not accept you, or you can do 4 years in the prison.
What do you want to do? I mean, I don't know how long safety is for.
He's 6 months and then 3 months aftercare. And that's inpatient.
Will I continue, will I still be on probation?
Yes,
And then the 4 years.
or either 4 years prison and you're not on probation, you're gonna go to prison for 4 years.
Judge, I don't think that's fair. I mean, I think. I
I'm
think
giving
that-
him a choice.
I understand, Judge.
So
I mean,
what's,
he's-
what's
but
not
he's a
fair is
first-time offender, you know,
he's on regular probation. He already has a felony conviction. I'm giving him a choice. He can either do 4 years in the prison or either he can do inpatient treatment. Those are his choices. I don't know what is not fair about me giving him a choice. Inpatient treatment, which is what they're recommending, or 4 years in the prison. Those are his choices. Like, that's what you all came up and agreed to with me. You said, we agree ISF. That's inpatient.
and that wasn't our agreement, Daniel. I mean, we talked about the time. We talked about a time offer and I asked LaShawn if she was fine with that and she said she was fine with that. So I don't know why.
And again, my understanding, I just remember asking to pay with recommendation, I asked if Sean agreed with that. That was what I asked.
I guess, Your Honor, I guess can we confer?
Yes.
We don't have an agreement, Judge.
Okay. All right, Darren Johnson. Who's the attorney for Darren Johnson? Hi. Morning. All right, so today is plea deadline date.
Yes, Your Honor.
All right, so jury trial, or you all come to an agreement?
It's gonna be a jury trial, Your Honor.
All right, how long do y'all expect this trial to last?
2 days, Judge.
All right, Ms. Ferguson, I need a jury trial date for criminal trial division.
Judge, wasn't there a expert wanted to ask for?
Yes, that is for, they're just enhancing a video.
Oh, I've already signed it.
Yes.
Just making sure.
Yes, no problem. And thank you for always dressing appropriately for court. I really appreciate that.
Thank you, Your Honor.
And we'll see what date we can get.
November 4th, you'll be an impact.
All right, November 4th, and it'll be an impact court.
Thank you, Your Honor.
You're welcome. Once you sign the reset form, you're excused.
Thank you.
Thank you. Oh, and let me make sure. State, on Johnson, have you already done a acknowledgement of discovery?
Thought you did, but I think you're double good.
All right, just to make sure it's uploaded.
What's the case number?
It is 2024 CR 2675.
Can't see what you're saying. I can't read it. Okay.
All right, if you'll have a seat and they will bring you a reset form. Once you sign that, you're excused.
Thank you.
Thank you. Gatto, yes,
That's fine, approach, Your Honor.
yes.
Yes, Your Honor. You had requested, the court had requested that I contact Delgado's bondsman. I have done so. And I also received a co-signer telephone number
Mhm.
and I contacted that and left a message.
Okay, all right, we'll go on the record.
Okay.
Judge, Mr. Johnson, Darren,
Yes.
there's not one uploaded into.
All right, she's a female. It's Darren. All right,
Yes, I said Darren.
okay, thanks. State, on Darren Johnson, we do need an acknowledgement of discovery. All right, and then could I have a prosecutor on Dean Pablo Delgado? Defendant is not present. Court is calling 2022 CR 3996, State of Texas versus Dean Pablo Delgado. Could I have parties announced for the record for the state?
Jason Gary, hand job.
Defense?
Ron Zimmerman.
All right, this hearing was scheduled at 9 a.m. It is now 11 a.m. and your client has not made an appearance. Have you sought to contact your client?
Yes, I have, Your Honor.
Do you want to place anything on the record or no?
Yes, I have called. I talked to him on Friday on the telephone, and then I called him yesterday and received just a recorded message. I called this morning, his telephone number, received the same message, subscriber is not available. I then contacted the bail bondsman listed for his cases and talked to the bail bondsman. They gave me a number of the cosigner. I did contact that cosigner, called that number and left a message on that and have not received a return call.
All right, and Deputy Laura, did you make an announcement for Delgado in the hallway?
Yes, Your Honor, I did. He is not in the hall.
All right, state.
State's requesting, I believe, a bond forfeiture or judge's warrant, Your Honor.
All right, the court will issue a bond forfeiture. Your client will be remanded without bond. If your client makes an appearance, the court will reconsider.
Thank you.
All right, thank you so much. All right, who's here? Yes, are you all ready?
No, we just wanted to talk to the court for briefly. Yeah. Well, they already know. This is kind of the rare occasion where the client is adamant that he's not using drugs. He's been in
I'm sorry,
custody.
what?
The client's adamant that he's not using drugs.
All right, so here's, I
And- but
understand
no,
what you're
but with
saying.
that- No, and let me just proceed, Judge. So with that, I asked Daniel, and I talked to Sean about it too. He's only been in custody for about a month. Is the court, amenable to order, follicle testing for him?
No. I mean, I'm given a choice. Here's the
No,
thing.
I know,
Yeah.
but just to, I mean, it's more scientific evidence for the court.
No,
You know what I
because let
mean?
me just tell you, he was supposed to be in felony drug court, but felony drug court was at capacity.
Right.
He has been missing since, what was it? January. Here we are in August. I've given him two choices. He can either do 4 years in the prison, or either he can do felony drug court. If felony drug court doesn't accept him, he's going to safety. Those are his two choices. I'm not doing a hair follicle test. You don't get to come in and say, hey, do this or do this, because he's been missing. He hasn't
Right, but
reported.
he's somebody with mental illness, Judge, and I think that can be mitigated with that, Judge. I think there's a lot of fear, of the court and, you know, being indigent, not being able to have a phone. I mean, I completely understand, you know, not being aware that there are programs out there that can help you get a phone. I mean, you know, obviously I shed light on that with
Well,
him
see, here's the
today.
issue with that. The issue with that is.
And I'm not a social worker, you know what I mean?
But here's the issue with that. I tell everybody who's placed on probation here, if there's an issue, they can come into court and let the court know. So he knew that. And he just chose to disappear since January. So those are his choices.
And is the court amenable to allowing a tap to be done while he's in custody?
Here's what the court is going to do. He can either go to prison for 4 years, or he is going to felony drug court, or either he's going to safety. Those are his only choices. That's where we are. So I don't know what else to tell anybody. So the only thing I need is a decision from him on
Well,
what he
I
wants to
guess-
do.
Well, no, Judge, so I think it's probably best for me to just subpoena the probation officer's records, because I do believe that there are.
I
some
am not
negative-
resetting this case. I'm not giving any more settings in this case. This case has been reset and
Yeah.
reset and reset. So we're proceeding.
It was recalled.
All right, so he's entered his plea of true. Mr. Pettis, if you can come down, please. We're back on the record in 2022 CR 3531W, State of Texas versus Jesus Pettis. Mr. Pettis, you have two choices. One, you can either go into inpatient treatment or felony drug court. If felony drug court accepts you, they may decide to place you in inpatient treatment. They may not decide to place you in inpatient treatment. They have a dual diagnosis program where they'll take care of mental health if that's your issue, if they accept you. They don't have all the funding. They don't have all the probation officers they need. Somebody needs to write their legislature and tell them, hey, these treatment courts need more funding. If they do not accept you, you're going to safety. You understand? Do you understand?
Yes, ma'am.
Or if you want, I can sentence you, excuse me. Or if you want, I can sentence you to 4 years in prison. Which do you prefer?
Really? No,
All right, so Mr. Pettis, here's the thing, it's your choice.
yes, ma'am.
So do you want treatment or do you want to go to prison? Now, if you go to prison, they have a therapeutic community. Maybe they'll let you in the program, maybe they won't. But you have a choice, treatment or prison. Which do you choose?
I'm trying to, it's hard for me to make a choice because I really don't know what the consequences are gonna render.
All right, so this is what I'm gonna do. I'm gonna make a choice for you. Court is finding violation of condition number 4 true. Court is gonna deny the motion, alternate amend conditions to include a referral to felony drug court that's in custody. If not accepted, then safe P. All right. And we can go off the record. Here's the thing, Mr. Pettis. If you think about it and you say, you know what, I should have just accepted the 4 years in prison. Guess what? Let the probation officer know. We'll bring you back and I'll give you 4 years. Do you understand?
Yes, ma'am.
All right. So here's the thing. In this court, to be successful, communication is key and you must report.
Yes,
Do you
ma'am.
understand?
Yes, ma'am.
All right. Good luck to you.
Thank you and God bless you.
Oh, thank you. God bless you too.
I'll do this.